$150,000 bond. I mean, I've seen murder cases with less than that, stabbing, shootings, all that kind of stuff. I would ask that you reduce the bond from 150 to $50,000.
DM number 097847, State of Texas versus John Anthony Ayala. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Alex Scharf for the defense.
Can I get John Ayala?
Yes.
All right, we're here. The defense has filed a motion seeking a bond reduction. State, have you had a chance to review the state defense's motion, and are you ready?
Yes, Your Honor, we are.
All right, defense, it's your motion.
Thanks, Judge. Call Yvette Ayala, the witness.
All right, Ms. Ayala. If you can raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand. Just state your name for the record.
Yvette Ayala.
All right, defense.
Thank you, Your Honor. Ms. Ayala, where do you live?
151 Bangor.
In San Antonio?
Yes,
All right. And are you working?
yes, sir.
Okay. Where do you work?
Commercial kitchen, Hudson, sir.
Okay. You married? Okay. And John is your son, is that correct?
Yes,
How old is he?
19.
18. Has no criminal record, is that correct? Now, you know that he's charged with a continuous sexual abuse for minors, is that correct? All right. And that the bond is currently set at $150,000. Is that correct?
That's what I did.
Okay. Now, do you have $15,000 to pay towards to a bondsman or to someone to get him out on that high of a bond?
Yes, sir.
All right. Is there anything property that you own or that you can, is there an amount that you can get together of money that you could put towards a bond to help to get John out of jail?
I'm currently trying to sell
Okay.
the money that I get back, so I'm trying to make sure I get my other kids set up. I don't have any more vacation time to take, so when I have got fitness and stuff for here, I have to take an on-day day off. So, but crunching the numbers and everything, I mean, I can do like 5,000.
All right. And in the event that the bond is reduced or or you're ever able to make it, where will John be living?
With my grandmother.
Okay. Are there any minors under 17 that live there?
No. Not that I can tell.
Is that your mom's?
No, it's my grandma. My mom's another option.
Okay. There are places where he can live that would not violate any conditions.
Yes.
House witness.
Just a few questions. Ms. Ayala, you said you owned your own home?
Oh, I'm still paying for it, yes.
You have a mortgage on your home. Okay. And the $5,000 that you said that you could come up with, is that are you taking into consideration other things, or is that just based on the sale of your home?
That's based on the sale of the home, and after I need to pay off what I need to make sure my other children are able, I need to space for them to live.
If you were going to sell your home, where you will live?
Our plan right now is to sell our home, get an apartment. I would like to pay it for a year, because like I said, with my hours not meeting, I don't want to stress over eventually.
So the 5,000 you're considering is in part due to your want to prepay your rent. As far as if he were to make bond, regardless of the amount, you said that he was out residing with you.
You know, the apartment,
And how old is your daughter?
my 16-year-old at my owner.
So you have two children under the age of 7.
I have three. My youngest, my son is 11.
11, 12, and 16. I understand correctly. And they would be residing with you. Offenseless.
Any further questions?
Nothing further, Judge.
All right,
Pass
Charlie,
with.
Charlie, something.
We rest.
All right, State.
Yes, sir. At this time, Sanders offer states if number 1, which has been previously tendered to defense.
No objection.
All right, and states exhibit number 1 is admitted into evidence. Just give me a moment to read it. All right, the court will hear argument. Defense is your motion.
Thank you, Judge. After reading the exhibit that the state tendered to you, I believe that most of the allegations happened or alleged to have happened when Mr. Ayala was a juvenile. To take that into consideration, that might have an effect on the jurisdiction of the case. 10 years old, no priors. Has a safe place to stay. I understand the seriousness of the charge. But $150,000 bond. I mean, I've seen murder cases with less than that. Stabbing, shootings, all that kind of stuff. I would ask that you reduce the bond from 150 to $50,000.
All right, State.
Yes, Your Honor. I guess 2 things from the state's perspective. Number 1 is just the offense in and of itself, which the court is well aware of, and the seriousness of these allegations, and the defendant's own admission to committing these offenses. The court's well aware that juveniles go to prison as well for these types of offenses. So the fact that he was a juvenile doesn't negate the age difference in this case, which I believe is, if I'm calculating it correctly, would be at least a 9-year difference between the two individuals. Secondly, in determining what is the appropriate amount to set in this case, obviously, of course, can take into consideration the ability for the defendant to make bond. And so in this case, I don't believe that Ms. Ayala has demonstrated through, or defense through Ms. Ayala has demonstrated the inability to pay, rather the inconvenience of being able to pay. She has other understandable uses and needs for that money, but prepaying a whole year of your rent, even assuming rent is $1,000 a month, that's $12,000 right there, and that's including, you know, it's not her the most convenient way for her to use her money, but obviously that I don't think that should be taken into play what the court is going to consider. And so we're asking that the writ be denied, that the bond is already appropriately set at an amount based on the nature of the offense, the specific allegations of this offense, and the lack of evidence to show that the defendant has the inability to make the bond as presently set.
Defense, it's your motion, so you have final argument.
Thank you, Judge. Miss Ayala, told the court she doesn't have the money. She's in the process of selling her house. God knows when that will happen. Or how much it'll be. But clearly she didn't have the money to make this bond right now. She's justified to that under oath. When and if the house gets sold, depending on what it gets sold for and all that. Her son is still in jail. And he's been there for over a month, and it's his first defense, and been throwing up all morning. He spit out. And we think that realistic just bond can be formulated. I believe full house arrest has already been ordered as a condition of his bond, um, where you can lower the bond to 50,000 and protect and give protection to the community, to the alleged victim. And so we're gonna say that we did show that she cannot make the bond right now at this moment.
All right. So this is what the court is going to do. The court is going to set the bond at $130,000. Full GPS, showing fees, no contact with minors.
Just
2021 CR 11159, State of Texas versus Evelyn Acosta. Can I have parties announced for the record, please?
Michelle Hayden for the state.
Thomas to defendants.
All right, we're here for sentencing. Are you Evelyn Acosta?
Yes, ma'am.
All right, you entered a plea of no contest on April 4th
Yes, ma'am.
and applied for deferred adjudication for the offense of arson, habitation, place of assembly. According to the plea bargaining agreement, punishment is assessed at a cap of 6 years silent. There's a $1,500 fine, and the state is silent on your application. All right, did you have a chance to review the report prepared by probation?
I have, Your Honor.
Any objections?
No, Your Honor.
All right, state any objections to the PSI and the TAP evaluation?
No, Your Honor.
All right, a state of silent, Mr. Hilary.
I call my client.
Could you raise your right hand for me, please? Do you solemnly swear to the testimony you give will be the truth and nothing but the truth so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record, please.
Sergeant Acosta.
All right, defense.
Please tell the court is given the chance today on deferred adjudication to keep this charge from affecting you for the rest of your life. Tell the court what is going to be your intended place of residence and with whom.
My intended residence to be live with my mother. Basically just prove to myself, my family, that I can redeem myself and be a better man, better husband, a better son for the family. I'm a hardworking person. I stay out of trouble about myself. I don't have that many acquaintances. I would just like to turn this around and put a smile on my kids and my wife and my family, that they're very disappointed in me. I myself am very disappointed in myself as well. Jail has been a big eye opener for me that I've taken for granted. My family, which is the most important thing in my life right now. I apologize to my family for any inconvenience that I put them through. You know, I know they're out there right now without me, and they need me. I need them. Just an opportunity to show them that I can do better and be better.
In addition to your mother, what other family support do you tend to have, like to have?
I have sisters and brothers, my father, so I have uncles and cousins who believe in me. They know that this has served me as a lesson, and they know I'm a hardworking person. They know I'm a low person, I'm a family person. That they all have. I have their respect and their support.
You understand that you already have 8 months back time. If the judge was to sentence you to start to a low number of TDC years, you may be out soon, as opposed to being on probation for many, many more years to come, undergoing a lot of treatment, doing a lot of classes, you're getting a lot of help. And if you mess up all of that, you could get a lot more time.
Yes, sir, I do.
You really take on the maybe potentially much more intense burden.
I know that none of that is going to be in easy, because like I said, I stayed away from being in any trouble at all for years and years. This time it was just a big fall for myself that I couldn't stay content with myself. I usually stay content with my actions and my before I can do something. I think before I speak and I act. It was just it was a big mess up. I was messing up bad. Like I said, I'm glad that my eyes have been open, and I knew that if this would have not happened to me, then I could have been worse for me as well.
Let's talk about the changes you underwent in custody the last 8 months. When it happened, what was your state of mind compared to today and why?
Um, at the beginning, I was stutter. I wouldn't know how to carry myself, how to carry myself with others. Now I've turned my life around. Like I said, I've turned my life around to a point where I want to make changes, not just change transformations in my life. Complete transformation where I can be unrecognizable. And I know I'm capable of doing such thing. I can be better and greater for my kids, especially for them. Show them that their dad is not what a mess up.
What services do you think you would benefit from when it comes to mental health, substance abuse, and being a father?
Sorry.
What services do you think this court can order you that you would benefit from when it comes to substance abuse, mental health, and parenting?
Yes, parenting classes, drug classes, and self control classes. Just programs that can help me be a big mental support for myself to you know be somebody greater and be a better part of society again, and just be part of my kid's life again, and not be as dumb as I was.
What were you thinking? What were you doing? And why were you doing what you're doing at the time of your My point, my question to summarize, what kind of drugs did you take at the time?
At the time I was new to crystal meth, and it's a heavy drug that it takes control of your mind, the hallucinations, the paranoia that it gives you. It's never been my choice of drug. It's just something that I fell on for losing my job and not be able to support my
What has
family.
been your choice of drug?
Ma'am,
What has been your choice of drug?
marijuana.
Okay.
Yes, ma'am.
All right. Are you receiving SSI or no?
No, ma'am.
All right. This is what the court is going to do. The court is going to grant your application, sending you to 6 years deferred education, $1,500 fine probated. You're to be evaluated for the DPRF placement. My understanding it's scheduled for May 19th, so he's going to remain in custody until that takes place and follow all conditions set by that. And he's going to follow that with the Genesis program, monthly year analysis, sober meetings, the MRT, proof of employment within 60 days of release. There's the no employment as a home health care provider with minors. There's the no unsupervised contact with minors. No harmful or injurious contact with Tiffany Acosta. There's to be regular reporting by Zoom or in person. Field visits 3 times per month, random, and that's upon release. Rebecca, is there anything else he needs?
No, ma'am.
All right. Mr. Costa, is there anything else you need from the court in order to be successful?
Just to grant me the opportunity to speak to show that I did that. Won't regret the opportunity that I get right now.
All right, thank you.
No.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, it's because you waive your right to appeal. You do not have the court's permission to appeal. Do you understand?
Yes, Honor.
All right, just up to you. We can go off the record. What are these tattoos about? What's that thing on your arm over there?
Oh, it's a smile now, carry later. Good times, bad times.
I'm sorry, what?
It's a smile now, carry later. Good times, bad times.
Smile now.
And
cry
carry later.
later. But I mean, what is it?
There's goals.
Skulls.
Yes, ma'am.
Okay, and what's the other thing?
City of San Antonio and the Spider Web.
All right, can I have a gang evaluation as well, Ms. Reyes? All right, thank you. Yes.
This courtroom hearing quickly turns intense as a 19-year-old defendant faces serious charges, including continuous sexual abuse of a minor. With a bond set at a massive $150,000, the defense argues that the amount is excessive, even claiming they've seen lower bonds in murder cases and pushes for a reduction to $50,000. They highlight that the accused has no prior criminal record, was allegedly a juvenile during many of the incidents, and has a stable place to stay if released, but the prosecution strongly pushes back, emphasizing the severity of the allegations, the defendant's own admissions, and a significant age gap between him and the alleged victim. They argue the family's financial struggle isn't true inability, it's about priorities. After hearing both sides, the judge makes a firm decision. The bond is only slightly reduced to $130,000, along with strict conditions like GPS monitoring and no contact orders. It's a powerful reminder of how seriously courts treat these types of allegations and how difficult it can be to secure release, even before trial.